Representative Kimberly Dudick. At this time, I'd like to introduce the chair of the committee, Utah Senate President Wayne Niederhauser, to say a few words.
Thank you, Edgar, and good morning, everyone, or good afternoon, wherever you are in the United States. It's lunchtime here, Mountain Time. Thank you for your participation in the webinar. This topic we're going to address today is an important issue that's facing legislators and college campus administrators across the country. So it's our aim today in the webinar to provide you a better understanding of the relevant federal and state efforts to combat and prevent sexual assault on college campuses, as well as best practices that colleges and universities are undertaking to address this issue. We have some great speakers. First of all, from the U.S. Department of Education's Office of Civil Rights, Mr. Timothy Sell and Caitlin Burks. Also, we have Paul Francis from the State of Washington's Council of Presidents. The biographies for these speakers can be viewed on the webinar link. Again, we really thank you for your participation. I would like to introduce now my colleague and Vice Chair of the CSG West Public Safety Committee, Montana Representative Kimberly Dudick. Representative Dudick.
Thank you, Senator Niederhauser. This is an issue that I've been focusing on in the Montana State Legislature for some time. I've worked with our university here in Missoula, the University of Montana, to identify best practices for sexual assault response and prevention. As legislators, I believe we are in a very unique position to improve how our states and communities respond to this problem, which has lasting, harmful effects on victims and their families, friends, and communities. As Senate President Niederhauser mentioned, we have a good lineup of speakers for this webinar. In order to complete this webinar within the hour, we will have our speakers make their presentations first, then we will open it up for questions and answers. If you have questions for any of our presenters, you may enter them into the GoToWebinar interface at any time. Now I would like to introduce Timothy Sell, Senior Attorney in the U.S. Department of Education's Office of Civil Rights. He will be accompanied by Caitlin Burke, also an attorney at the U.S. Department of Education's Office of Civil Rights. They will provide a brief overview of the scope of the problem and discuss Title IX of the Education Amendments of 1972. Timothy and Caitlin, thank you for joining us today. Their presentation is approximately 20 minutes long, and I look forward to hearing it. Thank you.
Well, thank you for that introduction. This is Tim Sell, and we have a number of PowerPoint slides that we're going to try to power through. That presentation is designed for more of a half a day. But Caitlin is going to take the first part of the presentation, and then I'll follow up about halfway through. So here's Caitlin Burks.
Hi there. Thank you for having us today. We're excited to talk about this issue. Just to give you some background on the Office for Civil Rights, if you're not really aware of our scope, OCR has 12 regional enforcement offices across the nation, and it is our job to enforce civil rights laws that prohibit discrimination on the basis of race, color, national origin, disability, age, and sex. We're here to talk about the sex discrimination, and particularly our PowerPoint will include highlights on our guidance on Title IX and sexual violence. Next slide. A roadmap for the presentation. As you can see here, we're first going to do an overview and talk about who's protected by Title IX, and then move into discussion about the notice and schools' obligations to respond to sexual violence on campus. We'll be speaking about responsible employees and reporting, and requests for confidentiality for students who report incidents of sexual assault. We'll be talking about how colleges are to conduct investigations on campus, as well as interim measures for people who report sexual violence, as well as remedies and the notice of an outcome of an investigation. Finally, we'll be talking about education, prevention, and training. Everything included in this PowerPoint are summaries of some guidance documents that have been put out from our office, and those include the legal requirements discussed in the 2001 sexual harassment guidance, a 2011 Dear Colleague letter about sexual violence, and a April 2014 question and answer document that filled in some details about the 2011 Dear Colleague letter. Next slide. As stated, Title IX prohibits sex discrimination in education programs and activities receiving federal financial assistance. And educational programs and activities are defined to include all of a school's operations, including school-sponsored activities and travel that occurs away from school. Next slide. Title IX applies to all public and private institutions receiving federal and financial assistance, and that does include elementary, secondary, and post-secondary institutions. And OCR views sexual violence as a form of sex discrimination covered by Title IX. We define sexual violence as physical acts that include rape, sexual assault, sexual battery, and sexual coercion. Next slide. Title IX protects all students from sexual violence, and that includes students with disabilities, international or undocumented students, included English language learners, and all students regardless of their sexual orientation or gender. We know that some students will face unique challenges when dealing with sexual violence, and that some students may require additional assistance and support from a university. Next slide. Title IX covers sexual violence between members of the same sex, and both male and female students can be subjected to sexual violence. Next, we'll be discussing about when a school is on notice of sexual violence. Under Title IX, a school has notice of student-on-student sexual violence if a responsible employee knew or in the exercise of reasonable care should have known about the sexual violence. Notice can be construed in many ways, and some examples of notice include a student who files a complaint or otherwise informs the school's Title IX coordinator of an incident of sexual violence. A student, friend, or other individual may have reported an incident to staff in an Office of Student Affairs, a dean, or another responsible employee, and we're going to define responsible employee shortly. And notice can also be given to the university through indirect sources, such as a member of the local community, postings on social networking sites, or the media. Determining when a university has notice of an incident of sexual violence is a fact-specific determination. Once a school knows that, or should have known, that a possible sexual violence incident occurred, the school then must take immediate and appropriate steps to investigate or otherwise determine what occurred. Please note that a school's response may be limited in cases where a student requests confidentiality, and we're going to talk about confidentiality later in the presentation. Once on notice, as I said, the school must determine what occurred or investigate it. If an investigation reveals that the sexual violence created a hostile environment, the school is then required to take prompt and effective steps reasonably calculated to end the sexual violence, eliminate the hostile environment, prevent its recurrence, and, as appropriate, remedy its effects. If a school delays responding to alleged sexual violence or the school's response is otherwise inappropriate, the school's own action or inaction may subject the student to a hostile environment. If this is the case, the school will then be required to remedy the effects of the sexual violence that could have been prevented if the school had responded promptly and appropriately. For example, if a school ignores a student's complaint of a sexual assault by a fellow student, and as a result the student was forced to remain in classes with the alleged perpetrator for several weeks, and the student's grades suffered because they were unable to concentrate in these classes, the school may need to permit the student to retake the classes without any academic or financial penalty, in addition to any other remedies that may be appropriate in that scenario. As we discussed, if a responsible employee is notified of an incident of sexual violence, that means the school is on notice that the violence has occurred. Determining who is a responsible employee. They are the ones who've been designated by the school to have authority to take action to redress sexual violence. They've been given the duty of reporting incidents of sexual violence or other misconduct by students to the Title IX coordinator or another school designee, or someone who a student reasonably believes has this authority or duty. As I said, when a responsible employee knows or reasonably should have known that possible sexual violence occurred, OCR considers the school to have notice of the sexual violence, which then triggers the school's duty to respond. Whether an employee is a responsible employee varies depending on the factors such as the age and education of the student, the type of position held by the employee, and the consideration of both informal and formal practices and procedures of the school. We mean that it may vary depending on such factors. It would be reasonable for an elementary school student maybe to believe that a custodial staff member or cafeteria worker has the authority to report, while it would certainly be less reasonable for a college student to believe that that staff member who works in the dining hall or as a member of the custodial staff would have the authority to report. One question we'll normally get is about resident assistants. And there's no bright line rule because resident assistants often have different roles at different schools, so it really depends on the duties of an RA. But if an RA is required to report other misconduct that would violate a school policy, such as drug or alcohol violations or a physical assault, then the RA would be considered a responsible employee obligated to report sexual violence incidents that violate school policy. Once a responsible employee has been told of a sexual assault, what should they do with that? From there, it should be reported to the Title IX coordinator or the other designee, and they should include all relevant details about alleged sexual violence that the student or another person had shared with them, and that the school needs to determine what occurred and how to resolve the situation. Next, we're talking about confidentiality and how that factors into reports of sexual violence on campus. OCR strongly supports the students' interest in confidentiality in these sexual violence cases. And often when students disclose incidents of sexual violence, they sometimes ask that their names not be disclosed to the perpetrator or that no investigation or disciplinary action occurs. The situations in which a school must override their request for confidentiality in order to meet Title IX obligations should be limited. And information should only be shared with individuals responsible for handling the school's responsibility. Even if a student doesn't specifically request confidentiality, to the extent possible, the school should only disclose information regarding incidents of sexual violence to the people handling the response, as I stated. To improve trust in the process, the school should notify students of the information that will be disclosed, whom it should be disclosed to, and why it's being disclosed. If a student does request confidentiality, the school needs to determine whether or not it can honor that request while still providing a safe and non-discriminatory environment for all other students. And the Title IX coordinator is generally best equipped to evaluate confidentiality requests. I've used the term Title IX coordinator throughout, and under Title IX, universities are required to designate one employee as an individual to coordinate their Title IX efforts. That's who we typically refer to as the Title IX coordinator. That will often be a standalone position, or it could be someone in the Student Affairs office. It really runs the gamut, but typically more often we're seeing a standalone Title IX coordinator as the person to handle and review these complaints. When a school determines it can respect a confidentiality request, the school should take all reasonable steps to respond to the complaint consistent with that request. And that request may limit a school's ability to respond fully, but it can still take steps to limit the effects of alleged sexual violence on campus. Some steps it could take to limit the alleged sexual violence without initiating a formal action or revealing a complainant's identity includes providing increased monitoring, supervision, or securities at locations where misconduct occurred, providing training and education, changing or publicizing the school's policies on sexual violence, or conducting a climate survey. When a school determines it must override a confidentiality request, the school should inform the student prior to disclosing that student's identity to the alleged perpetrator. And when that happens, it's important for the school to take whatever interim measures are necessary to protect the student and ensure safety of the other students. And we'll discuss what interim measures are later in the presentation. Tim will discuss that. With regard to confidentiality, although certain employees may have responsibilities that would require them to report incidents of sexual violence to the Title IX coordinator or designee, OCR recognizes the importance of protecting a counselor-client relationship, which would include disclosures of sexual violence incidents to pastoral and professional counselors or non-professional counselors or advocates. In that vein, it's important for schools to make students aware of any available confidential services so they know that they can confidently discuss an incident without it being reported up when that's appropriate. The pastoral and professional counselors whose responsibilities include providing mental health counseling also fall under that category as individuals not required by Title IX to report any information regarding sexual violence incidents that may have occurred with on campus or in a related activity. Further, non-professional counselors such as on-campus sexual assault centers, victim advocacy offices, women's centers and health centers, they're also not required by Title IX to report any personally identifying information about a student. And under Title IX, while these professions are exempt from the reporting requirement, OCR still encourages schools to collect aggregate data about sexual violence instances from these offices to identify patterns or systemic problems. Doesn't need to include personally identifying information about a student, but general information such as the nature, time, date, and location of the incident could help a school determine if there are any patterns in sexual violence on campus and help address those effects on campus climate. I'm going to turn over to Tim now, who's going to be talking about elements of the Title IX investigation.
Thank you, Caitlin. Before I get into that, Edgar had asked us to talk about the scope of this issue nationally and with regard to how it affects the western states. So I think nationally OCR receives more than 10,000 complaints per year total. Currently, we have nationally 423 open cases involving allegations of sexual violence, and those include both elementary and secondary and post-secondary. You've probably seen reports in the Chronicle of Higher Ed about the number of open complaints and the number of institutions involved. The numbers that I'm giving you are complaints or compliance reviews that involve both school-age students and post-secondary. So in terms of the number of open complaints we have in what we're calling the Western States regions, which include the Denver Office for Civil Rights, San Francisco OCR, and Seattle OCR, we have a total of 79 open complaints. And the status of those is that a number of those have been resolved and are in monitoring. Of the 423 cases that are open, a couple of them are in negotiation. 61 are in monitoring, which means that there's already been a determination made or an agreement entered into between the institution and OCR to resolve the issue, and that would be 61 that are in monitoring. In terms of Western states that directly affect the participants in this call, there are 79 open cases, 7 of which are in monitoring, and the balance are still under investigation. In the Denver office, which affects a number of states, there are 21 cases that are under investigation and 2 in monitoring, for a total of 23. Out of the San Francisco office, which affects only those institutions in California, There are 31 cases in investigation and 3 in monitoring. And in our region, which is the largest geographic region in the state, there are 29 cases currently open, 27 are under investigation, and 2 are in monitoring. So that's just a little additional information that's not in the PowerPoint about the scope of this problem and the number of cases that we're handling related to that. What I want to do now is talk briefly, and I'm just going to skim through some of these PowerPoints so that we have plenty of time for questions at the end. The elements of a Title IX investigation require that it be adequate, reliable, impartial, and prompt, and include the opportunity for both parties to present witnesses and other evidence. Some institutions provide for a hearing, some do not. It's not required under Title IX and the guidance that OCR issues, but if you do provide a hearing, it should be fair to both parties with those elements of reliability, impartiality, and promptness included in that. All persons involved in conducting an investigation must have training or experience in handling sexual violence complaints and the school's grievance procedures. We've had a number of cases where we might identify a Title IX coordinator and the person will indicate that they are the Title IX coordinator, but they're not sure what that means. In order to provide a meaningful grievance procedure, if that person is responsible for investigating and resolving Title IX allegations of harassment or sexual violence, that person needs to be trained and be familiar with this area, both generally and specific as to sexual violence. Next slide. Some issues have come up related to hearings, and as I mentioned, it's not required that the complainant be present for an entire hearing, but if the school allows one party to be present for an entire hearing, it must treat both parties equally. Next slide. There's some additional information related to hearing. Questioning about a complainant's sexual history with anyone other than the alleged perpetrator should not be permitted. And this is similar to what you might find in criminal proceedings, where most states have instituted what's called a rape shield law, where somebody who comes forward with an allegation of sexual assault can't be grilled about their entire history, sexual history, because it's considered to be beyond the scope of their allegation. Next slide. In many instances, in fact, this is one of the reasons that OCR issued its guidance originally. In many instances, when an allegation of sexual assault is made, there might be a parallel criminal investigation. Prior to 2011, what we were finding is that some institutions would indicate to us that they were waiting until the criminal investigation was completed in order so as not to interfere with an ongoing criminal case. And what the guidance letter does, and what you'll see in the Q&A that's available online, is that you have to take steps regardless of whether there is a criminal investigation pending. Even if you're not able to effectively investigate it while that criminal investigation is pending, you have to be in a position to provide some interim measures so that the victim or the alleged victim at that point in time is protected. It's helpful, next slide, it's helpful if you have a campus law enforcement agency or a community law enforcement agency to have some sort of memorandum of understanding between the Title IX coordinator's duties to investigate a campus sexual assault and whatever the police department is doing. So if you have a chance to meet with the local law enforcement ahead of time so that you have a common understanding of how the investigations will proceed in parallel, that would be helpful. Next slide. It's also important to know that under Title IX, schools must process all complaints of sexual violence regardless of where the conduct occurred to determine whether the conduct occurred in the context of an education program or activity or may have continuing effects on campus or in an off-campus education program or activity. And one example of this that we've run across is where there'll be some conduct that occurs off-campus, but where you'll have some on-campus discussion or chatter about that might create a hostile environment for the victim. So it's important to be aware of, even if something happens off campus and you think you don't have jurisdiction over it, if you're a campus official, it may still have ramifications on campus that you need to be aware of and be willing to investigate. I think both Caitlin and I have referred to interim measures on occasion, and what I want to say about that is, as with a situation where there's a parallel criminal investigation, institutions need to be in a position to provide interim measures to help assist the victim of sexual violence even before an investigation is completed. For example, provide counseling service, and if those are not available on campus, to be in a position to provide resources off campus to victims of sexual violence. In some situations, if a complainant requests confidentiality and the school may not be able to respond fully to an allegation of sexual violence and initiate formal action against an alleged perpetrator, the school must still take some immediate action to protect the complainant while keeping their identity confidential. So that talks about what Caitlin referred to earlier. If a student requests confidentiality, you could still take some relatively neutral interim measures to protect that student from possible additional exposure. How do you determine what measures to take? Really, it's a case-by-case basis. Interim measures implemented and process for implementing those will vary depending on the facts of each case. A school counselor could consider a number of factors, including, for example, what was requested by the complainant, what are the complainant's needs, what are the ages of the individuals involved. Keep in mind that we're dealing OCR-wide with both elementary, secondary students and post-secondary students. One factor might be the severity or pervasiveness of the allegations and any continuing effects on the complainant. In situations in the post-secondary realm where alleged perpetrator and the complainant occupy the same residence hall, you might consider relocating the alleged perpetrator, even if it's on a temporary basis, as an interim measure until the matter's been adjudicated or until the investigation is complete. In general, you should minimize the impact on the complainant. When I worked in post-secondary education, and we had several instances where the department in question responded to the complainant's allegation of sexual harassment by transferring that individual to another location. And that was problematic because the complainant didn't want to be transferred, and I think the rule of thumb is that even if it's on an interim basis, steps should be taken that affect the complainant the least. Next slide. When we get to an investigation and the institution has conducted an investigation that establishes that sexual violence has occurred, then we look to see what disciplinary action was taken against the perpetrator, what remedies have been provided to the complainant, and what changes have been made to the institution's overall services or policies and response to the issue generally to determine if there's been an effective response. I'm going to wrap up just by noting that both parties in a complaint investigation are entitled to notice of outcome. There are some rules that apply that are governed by the Clery Act and FERPA, which might limit the ability of the institution to provide full information about the results of an investigation. But I think if you review the Q&A and the guidance, you'll have some understanding of what's permissible in that area. And the last section in the PowerPoint deals with sexual violence training for employees and for students. I would suggest you just review the materials we provided, and we'll be able to cover some of those issues in Q&A. But in the interest of time, I'm going to conclude our remarks to give Paul a chance to present, and then we'll get back to it during Q&A.
Thank you, Tim and Caitlin. And as you mentioned, they'll be sticking around here for the Q&A. And also just want to remind everybody that if you have questions for any of our presenters, you may enter them into the GoToWebinar interface at any time. Now I'd like to introduce Mr. Paul Francis, the Executive Director of the Council of Presidents in the state of Washington. And for the next 15 minutes, he'll talk about how colleges and universities are responding to sexual assaults in college campuses. Mr. Francis.
Terrific. Thank you very much, and thank you all for having me here. Really appreciate the opportunity to speak on this important issue and to highlight some of what has been a multi-year effort here in Washington State. As was indicated, I represent the presidents of Washington's 6 public four-year institutions. You can see those all listed down there. Terrific colleges and universities. And although I only represent the public baccalaureates, this is the work that we're doing is collaborative with our 34 community and technical colleges and our 10 private nonprofit institutions that comprise the independent colleges of Washington. So while I'm not necessarily speaking on their behalf, the work that we're doing is collaborative here, and I am going to highlight that in particular because I do think if you're going to move the needle as a state on these issues, you have to have your institutional leaders working together. I've been very lucky that my presidents from a very early point said this is a serious issue. We want to be very assertive on this. We want to make sure that we're working with the legislature and with our partners in education in the K-12 and higher ed arena. And so I think that has really enabled us to go forth on this work, the fact that I do have such strong support from my presidents. Okay, moving on here, we're going to talk, there are my presidents, we're going to talk a little bit about what we know, talk about some college and university actions, and then hopefully spend most of the time talking about the work, state legislation in particular, that we've seen in Washington the last 2 years and where we're going, particularly on the issue around sexual violence prevention, which unfortunately doesn't get as much of a focus as it does, as response does. And so let's talk a little bit about that. And I want to make sure I'm being additive to the excellent comments from Tim and Caitlin. I wanted to highlight this report. You may have seen this, indicating the prevalence of campus sexual violence for both men and women. It is a major problem. We're seeing the number of reports increase. From our point of view, that's a good thing, which may sound odd, but that's a good thing to see that because it shows us, at least this is what we think, that more and more individuals feel comfortable coming forward to report an incident of sexual violence, whereas before perhaps that was not the case. The last 2 bullets indicate, as you can see, with respect to both prevention and response, that a small percentage are reported to an organization or agency of incidents, and that too few of the individuals on our campuses know about the resources that are available to them. And so that's certainly been a major focus of our work, is that we simply can't assume as college or university leaders that if you send out an email or if you have a pamphlet or if you put something on social media that you've done your due diligence. You really have to be proactive and listen to your populations on campus, students, faculty, staff, and others about how to reach them. And so we'll talk a little bit more about how we've tried to engage students and others in this work in particular. So that's a little bit of background information. Okay, for the next slide. What have we done here in Washington? So a little less than 3 years ago, my presidents, which regularly meet, said, you know, there's a lot of focus nationally on the issue of sexual violence. We have a variety of task forces and work groups on our campuses. What can we learn from each other? How can we share information? How can we make sure that we're really helping to move the needle on this issue in a way that's going to make a difference? And so therefore we organized for the first time ever in our state a conference on sexual assault prevention and response that I organized. It brought together more than 500 individuals from around the state, 50 different colleges and universities, 14 different sessions. One of the most valuable pieces in my mind was we have a base here near an Olympia, Joint Base Lewis McChord, and as you all know, the military has very much struggled with the issue of sexual violence as well. And so we asked some senior leaders on JBLM if they would be willing to come and talk about the work that they've been doing with respect to sexual violence prevention and response. Completely different cultures, of course, higher education and the military, but it was amazing to hear them come and talk and say, yes, this is a major issue. You know, we don't have the answers like you don't have the answers, but here are some things that we're trying to do, and JBLM is very progressive on the issue of sexual violence. Here are some of the things that we're doing that you might want to think about higher ed as you look to this issue. So that was incredible, the fact that we brought together for the first time everybody, experts, Title IX leaders, presidents, provosts, faculty, various advisors, and others to really sit down together and to talk about these particular issues. In addition here, as I mentioned, we have a variety of institutional task forces and work groups in the last few years on this particular issue. And I highlight the University of Washington in particular, which is our largest public baccalaureate institution. Their report in 2013 issued, included 18 different recommendations. For example, one of their recommendations was to create a single website with comprehensive information about sexual assault for students, staff, faculty, and others. Another recommendation included ensuring that there were enough sexual assault nurse examiners in close proximity to the UW campus, which has been an issue certainly in recent years. Another one was to make sure that resources were provided to students at all 3 of their campuses. They have 2 branch campuses, so let's make sure that we're not just focusing on the main campus, but how are we looking at all of our branch campuses, centers, and elsewhere, because as we know, students are accessing higher education in many different ways in the past. So we need to make sure that they get that information wherever they are. Maybe they're an online student, wherever. How do we do that? So I want to make sure to highlight that in particular because we've seen really good work from the institutions as well. Okay, next slide here. As you heard earlier, there are a number of statutes that govern sexual violence prevention and response for our colleges and universities. You've heard a little bit about the first 2 here. I want to highlight a piece of state legislation that we saw from 2015, Senate Bill 5518, that included a number of key elements, and I'm going to briefly highlight those so that you know. This is generally all around the response piece, and I'll talk about our work group, which is related to prevention, in a minute. Some of the elements of Senate Bill 5518, it required all institutions of higher ed to refrain from establishing different disciplinary processes on the same campus for a matter of sexual violence. This was already true in Washington State, but we had seen some examples from other states where athletes and others had seemed to have a different disciplinary process, and that was concerning to us and to policymakers, and so that requirement was placed there. Another requirement of the bill is that colleges and universities must make information available annually to all current and prospective students, employees, parents of students, and other including our reporting requirements. We're also required to conduct campus climate survey, both the four-year institutions individually and our community and technical college system. We have a unified system for our 34 schools here, and included various elements that were in that survey. Some institutions had already had been conducting climate surveys for a number of years. Others hadn't done that. So that was a requirement and included a reporting piece in there. And I'll talk a little bit more about some of the challenges that we're seeing with respect to campus climate assessments. Overall, I think they're a good thing. I'm glad that the legislature included that. But there are some really important caveats if you go down that road around assessing students and others. It also required the public 4- and 2-year institutions and our independent colleges to report on our progress thus far to enter into memoranda of understanding with local law enforcement. Generally, our institutions have a very good relationship with law enforcement, and some of us have had MOUs and some of us haven't. And in fact, I just submitted that report to the legislature in June. That's on our website if you want to take a look at it. We have a model MOU that's available for anybody to take a look at, and that is really important to clarify the roles and responsibilities there with law enforcement. And I know that's challenging. Some institutions and some localities don't necessarily have great relationships, but we see that as being critical, and we're very happy to see that placed in the bill. And then finally, it required institutions to distribute information about sexual violence policies and procedures annually to everyone in the campus community, which we heard are already been doing, but embedded that in state statute. And so that's Senate Bill 5518 that passed in 2015. So we're working through many of the elements from that bill. And then let's talk a little bit, going forward to the next slide, let's talk a little bit about some of the work that we're doing with respect to another bill that passed in 2015 in Washington State related to prevention. And, you know, it's very interesting in Washington State because we have a divided legislature. Our Republicans control the Senate and Democrats control the House. We have a Democratic governor. But I have to say that our legislature has worked really well together, both Democrats and Republicans, on this issue, which I think has helped us. And so while we had that bill that I just mentioned related to response, the chair of our Senate Higher Ed Committee said, you know, we don't spend enough time on prevention. Can we please spend some time during the interim period when the legislature is not in session really thinking through these issues? And that came out of that. So you see some of the goals for that task force to really look at best practices, awareness, how we really highlight that. The task force includes 14 members. It includes one representative from each of the public baccalaureates, a representative from the community and technical colleges, a representative from the independent colleges of Washington, and then it includes representatives from local law enforcement, our sheriffs and police chiefs, the prosecuting attorneys. It includes a nonprofit representative. It includes a representative from the Attorney General's office and the Student Achievement Council, which is our coordinating body for higher education in Washington State. And so the legislature put a lot of faith in us to do this work over a 2-year period and to do it well. The Council of Presidents staffs the Campus Sexual Violence Task Force. Let's talk about the next slide here. So this is the work that we've been doing over the last 18 months that is going to continue until the end of December. We issued a preliminary report last December that's available on the website there at the bottom. Please feel free to take a look at it. We'll be issuing another and final report this December. As you all know, this is incredibly complex. And, you know, I think what we've all come to the table saying, we've had 10 meetings thus far, open meetings. We've tried to be very transparent and really make sure that we're inviting legislators and legislative staff and anybody that wants to talk about this issue to say, we don't have the answers. We're doing some really good things in Washington State at the local level. How do we scale that up or transfer that so that we're really leading the nation? And that's our goal, that we're leading the nation on the issue of campus sexual violence prevention and response. Most of our time is spent on prevention, but given the reporting requirements in the other bill, these are interconnected, so we're spending some time on response as well. And I want to highlight, you can see there that we've organized ourselves into 6 subcommittees. I want to highlight a little bit of what we've been talking about there related to the subcommittees. First, I want to say that we've had panelists from around the country come and speak to us. We've had local law enforcement talk about there's some great programs that are happening in Washington State with law enforcement. There's some terrific programs in the K-12 system as well around prevention that is incredible. We've heard from researchers around the country, so really trying to get a sense of what's out there and what could we hope to highlight as we produce some recommendations. So let me very quickly go through these subcommittees. Campus climate assessment. The community and technical colleges recently disseminated an assessment to their students. Their response rate has been 2% thus far, so they have had some challenges getting responses from their students. They've also had some challenges in terms of pushback from some of their colleges around ESL students, which aren't being, haven't received the questionnaire. Students who are under age 18, they haven't received the questionnaire as well. And so I think there'll be some good information that comes from the community and technical college assessment, but there's been some real frustrations with that as well. And that's not just true in the 2-year sector, but in the 4-year sector as well. And those are the kind of things you have to think about as you go through this process about what are the results, and then how transferable is that into action going forward. The prevention subcommittee is really looking, as I mentioned, at some of the terrific resources that are out there in K-12. We have invited our Office of Superintendent for Public Instruction because if you think about it, students have 18 or years more of socialization before they get to our campuses. So if we don't start having these conversations in K-12, when students are younger, then I think we're only going to move the needle so much. And so we really want to make sure that we're thinking about how we can deliver some of the messages around prevention to students at a younger age without, giving necessarily a lot of Olympia-level mandates that, our school districts will push back upon. But how do we do this in a way that feels collaborative and that really kind of adheres to the ethic of local control that is really important in Washington State? Our criminal justice system work group is looking at some resources for judges around sexual violence. We feel like there's some knowledge gaps there that perhaps we could recommend, so we're really trying to look at some key resources for additional information. Our advocate confidentiality group is looking at, we have a Public Records Act here in Washington, and so we're looking at, does that need to be amended based on some of the things that you heard from my colleagues? Does that need to be amended so it provides better confidentiality? That's a really complex area for us. So we're trying to really look at that. And the Public Records Act, that's a major issue as well for us around public records requests, of which we get a lot. Student conduct. So this has been an issue specifically related to transcripts. What information do you put on a student transcript related to campus sexual violence? And there are strong opinions on both sides about that. Some believe you should put that if a student was found in violation of a particular conduct code related to sexual violence, committed sexual violence. Should you place that on a transcript? So we're trying to kind of weigh the pros and cons of that. There are good arguments on both sides, but that's one example of an issue they're dealing with. And then finally, special populations. There are specific issues related to GLBT students, related to students with disabilities, international students, undocumented students, campus sexual violence against men, for example. And so we're really trying to make sure that we don't paint too broad a brush, and that we do, to the extent that we can, a deep dive into some special populations and how we're addressing the needs there. So that's certainly critical. And then here's our website. Here we've got a lot of information on there. Please take a look at it. Like I said, our final report will be issued in December, so we're right in the middle of this. I hope to come back to you in a year or two and say that we've really proven to be effective in our work, but I would say the jury's still out, but I think we've made some good progress thus far. Thank you.
Thank you, Paul. And now we'll go into our question and answers. Please, if you have questions, please go to the GoToWebinar interface and put it in there. And then also just want to remind folks that copies of the presentations can be uploaded from the CSU website. You'll receive an email immediately following this webinar to get that information. That will also include a survey. Let's go to the first question that we have. First question, I think this is for Timothy and Caitlin. Can a campus issue its own no contact order between a perpetrator and complainant if one is not court ordered? And how would the no contact be implemented on campus without a court order?
This is Tim Sell in Seattle. Well, I think that most institutions would have the authority to limit contact between students administratively and to enforce that through the student conduct code. It wouldn't carry the same weight or breadth as a court-ordered or court-issued no contact order, but it seems to me that it would be within the inherent authority of an institution to limit contact between individuals. Be similar to what might be called a trespass invocation. If you wanted to restrict the ability of a student to be in a certain area for certain reasons, you can limit access to public and private areas on your campus through a trespass notice.
Thank you. Question for Paul. I guess in describing your engagement with the Washington legislature, if you can talk about perhaps some of the, what made that success or how that worked. Can you talk about what were sort of the elements that, from your perspective, that brought everybody together to work on that legislation?
Yeah, that's a good question. So our legislature is very interested in the topic of sexual violence, period. I believe we were the first state this last session to require that all rape kits be tested just around the state. And so the lead for that has done some great bipartisan work. And so I think we're very, very lucky that that legislators have approached this from a bipartisan view. Like I said, we've tended to have a little more focus from the Republicans on prevention and a little more focus from the Democrats on response, but both of those are critical. And so, in my conversations with legislators, I think what I've tried to do, and I think this is really important, I think you have to be really honest. I used to be legislative staff. I think you have to be really honest with legislators. And I think you have to say, look, this is what we feel we've been doing well. This is what we feel we've been doing poorly. Here's what we're doing, and here's how we think you can help. And I don't think you should be afraid to make a fiscal ask there, but don't just make it about money. You can't just say, well, we'd love to do this if we had a couple million more dollars, because at the end of the day, parents and students want to be safe on campuses, and that's the responsibility of college administrators. And so, I think we've been really lucky because we feel like we've had a very honest dialogue with legislators, and I constantly communicate with them. I send them updates regularly, and they've been great about saying, look, we're not the experts on this issue. We can take a look at what other states are doing, and we see that there's a lot of proposed federal legislation and what's happening from OCR and such, but we want you to own this issue, and we want to own it. So I think it just feels to me like we're all in the same place. Are we always going to be in the same place? I don't know. I mean, we'll have to see what recommendations come forward at the end of the year. But I think because we're all focused, we're laser focused on trying to help to solve this issue. It's been it has led thus far to, I think, hopefully a better outcome for our students and others. So.
Thank you. I have another question here. I still don't understand why felony sexual assaults are adjudicated on campus when no other felony is or ever would be. It seems to send the message that sexual assault is not a serious crime. Is it at all to do with the victim not wanting to go to the police? Perhaps Tim or Caitlin?
Yeah, this is Tim and Caitlin in Seattle. Well, I'm not 100% sure I agree with the premise. I think that any student who was charged with, regardless of whether it was a sexual assault or otherwise, any student who's charged with a felony relating to their conduct on campus, whether it would be a theft or an assault against another student or some sort of intellectual property issue involving theft or trespass even, or burglary, I'm pretty certain that most of those would be covered both by the criminal justice system and by a parallel student conduct system. So in that respect, I think there are many instances where a conduct of a student would be covered under both justice systems, so to speak. With regard to sexual assault, I think part of the phenomenon that we're seeing is attributable to what Paul referred to in his presentation, and that is that institutions want to get ahead of it and prevent it, and also at the same time have effective responses to it. So there have just been a lot more efforts both nationally and regionally and on individual campuses to provide effective responses to sexual assault.
Great. Thank you, Tim. Well, I think we, in looking at our,
You might be receiving one.
you might be receiving one more question. We'll take.
Let me find out. Yeah, we do have one more question. I'll go ahead and read it. My question is for Paul. Do the colleges and universities in Washington have campus police? We have had problems with our campus police wanting to collaborate with local police authorities because they feel they are qualified, certified police officers. Do you have any pushback from campus police?
Yeah, that's a really good question as well. I think we're fortunate because the chair of my task force is the chief of police at the University of Washington, Dr. John Vincent, and he's on our statewide association of police chiefs and sheriffs, and so we haven't had any problems whatsoever. Now, that in terms of the structure, our public baccalaureates each have their own police forces. The community and technical colleges don't. I mean, they may have a safety officer or something like that, but they just don't have the same level. And most of our private nonprofit colleges and universities are, small enough that I don't know that maybe Seattle U, or Gonzaga, but I don't think that they do as well. And so no, we have not had any problems whatsoever. I mean, we have had some challenges just in terms of, what are the expectations of our colleges and universities and local law enforcement, but we haven't had any turf battles in terms of our chief of police. And, if I did have any of that, to be honest with you, I would probably go to my presidents and I'd say, listen, we have some issues here. I really need your help in communicating that we just can't have these turf battles, because that can be an impediment, certainly.
Thank you.
We did receive one more. It's not as much as a question. It says, I don't have a question, just a comment. Great conversation today. Thank you. We need more conversations around this issue. Delaware just passed House Substitute 1 for House Bill 1, which I was the prime sponsor of campus sexual assault. I agree with your comments with respect to K through 12 prevention needs to start much earlier. Thank you again for this webinar. So with that, I'm going to go ahead and pass it over to Edgar. Thank you.
Well, again, I want to thank all of our speakers, Tim, Caitlin, and Paul, for their participation. Again, this webinar also will be uploaded and available for folks to listen in, and we'll definitely be following up with information post. This will be a survey as well. Before we close, I do want to invite our chair and our vice chair, both Senator Niederhauser and Representative Kimberly Dudick, to make any final comments before we wrap up the webinar.
Well, this is Representative. Go ahead, Senator.
This is Senator Niederhauser. Yes, thank you, Timothy, Caitlin, and Paul, and thank you, Edgar, and all the staff members. Wow, what a great webinar and some great information to help us in our responsibilities as state legislators. And thank you, Representative Dudick, and your leadership on this issue. We look forward to seeing everybody in Coeur d'Alene next month, and hope you have a great rest of the summer.
Thank you, Senator.
Thank you very much, Senator Niederhauser. And this is Representative Dudick. I just wanted to invite anyone who is interested in learning more about this topic to Missoula, Montana, August 15th through the 19th. We have organized a class at the University of Montana called Sexual Assault Response and Prevention. And we are looking at the scope of the problem in our state, best practices as far as law enforcement, prosecution, and what our schools are doing, and then how we can look at preventing it. So I appreciated that part of the conversation today, and I look forward to learning more about what's going on in Washington. If anyone is interested, please feel free to contact Edgar or me at kimberly.dudick@gmail.com, and I would be happy to talk with you more. Thank you.
Thank you, Representative, and we will definitely make sure we forward that information about the event in Montana to all of the participants to this webinar. With that, unless any of our speakers have any final comments, well, with that, thank you everybody for joining us, and please feel free to call us if you have any questions. Have a wonderful day. Bye.